everyone. Thank you for joining our regular Saturday webinar, and thanks a lot for your support as usual. Welcome to the weekly Saturday knowledge sharing webinar organized by Mehta and Mehta. And today's topic is an insight into meetings of Board of Directors and provisions of Secretarial Standard. Friends, so Secretarial Standard 1. Board meeting, as I will say that CS is the only professional who are in the board meeting allowed, who get very closely connected to the board, who get opportunity to understand how the board behave, how the directors discuss, and how they react, how they look at the situation, how they solve the situation. If we take it seriously that as an opportunity got to us, we can explore ourselves and excel ourselves to a great extent. Actually, that is the opportunity available only to this profession, which give us chance to understand the board well, directors well, the business well. Each and every department operations are in agenda. If we read that properly and understand from each and every department, don't you think that knowledge, the understanding, what we will gather will be immense. Majority time it is observed that agenda is, people say, CSS prepared. My dear friends, it is not prepared, it is compiled by Secretarial Department. If CS get that time, maybe many times it is urgent, so you are not getting time. But at least glance and understand, and after board meeting, also if you understand that, you will be part of that discussion and you can surely contribute. Friends, that is required, that it's not compilation, but understanding each and every information, which is part of agenda. And as such, board meeting is so important because all the important decisions are taken in the board. And as everyone knows, company is unnatural person and board is the only authority which act as a mind hand of the company. And we as a company secretary draft that papers which will decide what company will think, what company will act, how it will act. As per, of course, law and regulations, how important role it is. And the same is to be performed in board meeting, agenda, notice, minutes, and its proceedings. And so the importance of board meeting, so our presence, and that's why this secretarial standard to, put in intact the sanity of this entire process, which will decide the future of the company and a lot of stakeholders. And today's topic, very important, an insight into meetings of Board of Directors and provisions of Secretarial Standard, which is presenter is Ashwini Nandar, Senior Partner of Mehta and Mehta, very well experienced, and she specializes in LODR and has a vast experience relating to takeover, LODR, Companies Act. She is certified post trainer, regularly trains corporate in insider trading, RPT, BEAT, and also post training. She is also certified, so you can see this. And welcome, Ashwini. Yeah. Now we have with us today's our panelist, Valerie Gupte. Valerie Gupte is a commerce and law graduate from University of Pune, fellow member of ICSI and ASCI from Chartered Governance Institute of UK. She has qualified diploma in corporate governance by the ICSI, as well as certification in global reporting initiative standards by GRI Institute of Sustainability Reporting. She is a certified mediator and registered independent director in the database of ISA and has recently joined CS of Skoda Auto Volkswagen India. Before she worked with CS CEAT Limited, and she was a member of CSR task force, and she is having a vast experience in various fields. And welcome, Valerie. Thanks a lot for your time. We are sure that you are also again coming to our platform. Thanks a lot for your time, and we appreciate your time allocation to our program. Thanks a lot. Valerie is having post-qualification 20 years experience and worked in corporate secretarial legal function of various multinational companies, listed entities like Bajaj, WNS Global, Tech Mahindra, KPIT Technology, Thermex. She is been associated with CS Institute as panelist with 15 Global Golden Jubilee National Convention ICICI on the topic sustainability. She is a recognized successful company secretary under 40 under the Empowered Women Drive of ICSI occasion of Women's Day. Fantastic, Valerie. Thanks a lot. Oh my goodness, I thought still it is. She was previously a member and chairperson of Mehta subcommittee of Pune chapter, monthly newsletter publication, and currently speaker, faculty member at various seminars, webinars organized by ICSI on the subject like ESG, sustainability, corporate governance, SEBI LODR, secretarial standard, etc., etc. It is. She is also passionate about social initiative and works in association with several non-profit organizations like Deepastham, Mehta, New Life Foundation, etc. Oh, now it's over. Thanks, Valerie. So now, of course, our other panelist is, as usual, Mr. Bala and Mr. Sudhakar. Mr. Sudhakar, thanks a lot. And Mr. Bala, as usual, we have decided not to introduce them because they are now known among everyone. And with this, I'll request Valerie to say a few words on the topic, and then Mr. Sudhakar, and then Bala, and then Ashwini can start the presentation. Thanks. Over to Valerie.
Thank you, ma'am, and thank you for inviting me for this webinar. And it's always been a pleasure to be part of these knowledge sharing discussions by Mehta and Mehta. The topic secretarial standards, I think we've been handling it for quite a long time, but it is still very important for us. Since it is again part of the board meeting management and more to standardize the corporate governance practices across companies. And we know that law prescribes a certain number of board meetings, the quorum, the way the minutes have to be prepared, circulated. So all this is only to have a structured way of conducting the meetings. So I was just saying that, as ma'am rightly said, that the company is an unnatural entity which is owned by the shareholders but governed by the board of directors. They are the management of the company. So to have the best governance practices, the secretarial standards which are prescribed by the institute help a lot and guide the company secretaries to conduct it in the right way. So that's in a nutshell about the secretarial standards. I think while we deal with it in and out, having access to the board meetings and guiding them through the board management and taking care of secretarial standards is a core requirement for a company secretary, and I think we are all working towards it. So that's maybe a brief from my side. Over to the other panelists, and then we can continue with the discussion. Thank you.
Yes, Doctor.
Yeah. Good morning, everyone. And in fact, one of the most important duties of a company secretary is to hold the board meetings. And I am sure that every company secretary, whether with 1 year experience or 25, 30 years of experience, we do handle the board meetings. But how many of us know really the importance of the board meetings is a real question, because the kind of final points what are there involved with these board meetings. In fact, according to me, Companies Act 2013 has brought the seriousness of the board meetings as well as the importance of the company secretary. Prior to this, when the old 56 Act was there, when I was in Reliance, I used to interview a lot of company secretaries. They used to say that, sir, I am a company secretary of the company, but I don't handle the routine things like handling the board meetings, preparing the agenda, and drafting the minutes. This is all my subordinates do it. I do much more than that. But Companies Act 2013 is not giving that kind of a privilege to the company secretaries. The company secretary himself or herself have to be thick and thin into the drafting the agenda as well as drafting the minutes and also holding the board meetings. In fact, whenever a company secretary wants to handle the board meeting, three things are very, very important. The first and foremost thing is they should be completely thorough with the provisions of the Companies Act 2013 because any kind of non-compliance may lead to the validity, question the validity of the board meeting and the decisions taken there. So one need to be synced with the provisions of the Companies Act. After this, secretarial standards, SS-1 of course. And several times the question comes that people used to still grumble even as on date also that SS-1 has overridden the Companies Act. Several times in several forums for the past almost 9-10 years, I am saying this, that right from the inception of 1st July 2015, when this SS1 was mandated, I used to say that this is not overriding the Companies Act, but this is a part of the Companies Act. Section 118, subsection 10 has recognized SS1 and made it mandatory to comply with. And it is a part of the Companies Act. Whether we like it or not, we have to comply with the provisions of SS1. In addition to Companies Act and SS1, we have to also see the provisions of the Articles of Association. Because this is a very, very important aspect. Several times it may so happen that Articles of Association prescribes the modalities of holding the board and committee meetings. Without overriding the provisions of the Companies Act and SS1, the articles may impose several restrictions or modalities as far as holding the board meetings are concerned. So the company secretaries have to be familiar with these three things before holding the board meetings. Several other finer points are there, which we will discuss over the presentation of Ashwani. I give a pause here and request Bala to take it forward. Thank you.
Good morning to all of you. I have a great pleasure in welcoming you all. And as Sudhagar and Dipti has put it, the importance of the SS1. I also like to bring to the notice of the delegates. Dipti and Sudhagar were part and parcel of Secretarial Standard Board who were involved very much in drafting, revising, re-revising, and even instrumental bringing with a wonderful guidance note. As Sudhakar puts it very categorically, it's overburdening, etc. No, it is not like that. It is whatever the law is there, wherever law is not clarified, law is, we don't follow the things. The secretarial standard gives with the, along with the guidance note, gives ample illustrative examples of the situation, even some of the working. How do you calculate the agenda dates? How the calculation, what is to be excluded, what is to be included? It is very, very amply clarified for the use of the company secretaries. And I think Sudhagar also will agree with me. He has also been advocating in many forums. Some or other people don't read even the guidance note, which has been brought out by the institute, putting a lot of efforts, which is really, really, a master guide for all of us. Another thing is that Dipti also said very clearly that the company secretary is the only professional who are present in the board meeting right from the beginning till the end. And he knows what is the thinking of the company, what is the management, what is the strategy, what is the planning, what is being implemented, how it is monitored, everything A to Z is aware of it. If company secretary is not going to be thorough in his job, And ultimately, not only he puts the company into the problem, directly into the problem, he himself is come into the problem. And again, Sudhakar puts it, oh, my subordinates are doing, I'm not doing it. That is where the problem lies actually. Because what happens is the whole process, we tend to ignore many minute things, trivial things. If many of you have seen, there are various ROC orders have been passed left and right in regarding convening the meeting, not providing the explanatory statement, proper minutes writing, etc. And all this, n number of things are there. There are a lot of nitty-gritties where the company secretary has to put in place and he has to take care of it. That is a system. So company secretary has to ensure it is apart from releasing the agenda, conducting the meeting, ensuring the proper compliance of the company's act in order to have the company's reputation and spoiled. That is important. So as we go along, I think with the expert view, what we have from Valerie and Sudhakar and Dipti, we will hear the insight of it, and we will also have the practical experiences of them in certain matters, etc. And all the things. And another thing, as usual, you are requested to put all your queries in the chat box. We will be taking periodically as and when which are relevant as the things are going on. At the end of the session, if you still have some queries, some of you can raise your hands. We'll permit you to speak. You can actually speak. Those things also will get answered. Only one thing, my request is, please do not bring any particular issue to your organization, which is in the nature of the opinion, because this forum is actually analyzing the law, rules, regulation in general and providing the interpretation of the act in general, not to the specific opinion in the nature of the opinion, because without knowing the full fact, this forum will not be able to answer. Otherwise, that will actually mislead. That is my request to all of you. Thanks a lot. Ashwini, it is your turn. Take us through.
Good morning, everyone. Feeling a bit nervous because two stalwarts of secretarial standards are here. So please, if I get wrong, please correct me. So
your experience is quite enough, Ashwini.
Ashwini, that shows
I'm not looking at the panelist at all. I'm just going to get through the presentation.
Ashwini, you are actually very humble. We know you are much expert. Don't say all the things. Go ahead.
Thank you, sir. So basically for today, I have covered sections 173 to 175 Companies Act and Secretarial Standards 1. A brief background regarding today's insight presentation is that board meetings, as everybody is aware, is an essential aspect of corporate governance. A lot of decisions regarding the management and operations of the company are made during a board meeting. Most of the times, we get a feedback from company secretaries is that it is too stringent to follow the compliances under secretarial. But whenever there is any litigation or any issue in the organization, these secretarial standards are the one who precisely save the company secretary or the management if they are properly complied with. The secretarial standards have been brought in to promote transparency and consistency in the meetings. And also it provides a comprehensive framework on how board meetings should be convened, conducted. So everything is given in secretarial standards with respect to practices to be followed. Also, I urge everybody to go through the secretarial standards guidance notes in case they are stuck at any point of time. So basically everything under the Companies Act with respect to board meeting and shareholders meeting is covered in SS-1 and SS-2. So when we talk about section 173, it talks about how many board meetings have to be held in a year, what is the participation, what is the notice and everything. So we have to understand that first board meeting of any company which is incorporated has to be within 30 days of its incorporation. After that, at least 4 meetings have to be held annually with a maximum gap of 120 days. So this is given under section 173. So it also has some exceptions like one-person company or a small company or a dormant company or a private company which is a startup. So these kind of companies can have one meeting in half year. That is a half calendar year. One meeting is enough for such companies. However, for the rest of the companies, they will have to hold at least 4 meetings a year. Participation in board meetings. So pre-COVID era, there were certain restrictions on participation for board of directors through video conferencing. However, they have been relaxed. And now all these restrictive items can now be taken up through video conferencing, and meetings can be held in person or via audio video means. The notice of meetings have to be sent minimum 7 days in advance. If there is a shorter notice, then if we have to make sure that if there is an independent director, he is present at the meeting, or if any such director is not present, but a meeting is held, then the decision is ratified by the independent directors. What is the penalty for non-compliance? If we do not comply with Section 173, there is a penalty of 25,000 for officers failing to provide the required notice. So as I earlier told you, one person company, small company, and dormant companies can hold one meeting per half year with at least 90 days gap. Provisions for companies with only one director. Then we come to Section 174. 174 talks about quorum of directors for a board meeting.
Ashwini, before you go to 174, there are a few points I would like to bring as far as 173 is concerned. Okay. Can we go back to the previous slide, please? See, in section 173 is giving an option to the director to attend the meeting physically or through a video conferencing. In fact, there was a question earlier that is it mandatory for the companies to provide the video conferencing facility or it is optional? If you see the Secretarial Standard 1, which was there on 1st July 2015, we have taken liberty of saying that where the company provides the VC, the director may opt to attend the board meeting in physical mode or through video conferencing. But when the SS-1 was revised in 2017, that point of time, ministry said that it is, as per section 173, it is the right of the director to attend the meeting in physical or through video conferencing. And it is obligatory for the companies to provide the video conferencing facility. That's why if you see the SS-1 revised, which came from 1st October 2017, you will see that the companies are under obligation to provide the video conferencing. And the notice what you are issuing for the board meeting, it has to clearly give this provision to the companies, to the director to opt for attending the meeting through video conferencing. If he is opting for, then he has to write to the company secretary to provide such facility, blah, 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 blah. So please ensure that whenever you are issuing the board meeting notice, this option is to be provided. That means you have to clearly mention that unless until you are holding the board meeting through video conferencing. But if you are holding the board meeting in physical mode, then you have to write in the notice very clearly that the directors are having an option to attend the meeting through video conferencing. Number two, while attending the video conferencing, as per the rules, we all know that very well, that the directors have to give a roll call. In the roll call, they have to give 4 affirmations that they have to give their name, from where they are attending the meeting, they have received the agenda and other papers well in time, and apart from them, no one else have access to the proceedings of the meeting. These are the 4 affirmations that the directors have to give while attending the meeting through video conferencing. Most of the times I have seen, and several company secretaries when I interacted with them also, that while attending the board meeting, in fact, I have seen it in the what's called as in the Teams call meeting when I was in Reliance also. People are shy of switching on their videos. In fact, I have taken the liberty in Mehta that whenever we have our internal meetings to switch on the video, that is mandatory for the person who is speaking. In the board meetings, with some directors, when they take the roll call, they were not switching on the videos, which is not correct. So my advice to participants and my request to them is, please inform all your directors that whenever you are attending the meetings through video conferencing, to please switch on the video as far as possible, unless until there is some for about a half a minute or so you have something, it's a different thing. But otherwise, it is advisable to keep the video on. Number two is that whenever, in case of a video conferencing meeting, whenever a director wants to speak, he has to identify himself. I am so and so, or something like that. Because sometimes, for any reason, if somebody is switching off the video, there is some kind of a bandwidth problem is there. So he might be switching off the video. That point of time, he has to identify himself before speaking that. And thirdly, it is the responsibility of the company secretary, especially in case of video meetings, that whenever a decision is taken, the sufficient quorum is present. Sometimes it may so happen a director may got disconnected because of some kind of a technical issues or something like that. That point of time, if there are 2, 3 directors got disconnected and the quorum is not there, because please remember that you are recording the board meeting. There will be a problem if the proper sufficient quorum is not there. Tomorrow someone can challenge, any director may challenge the meeting, or your secretarial auditor himself also may say that sufficient quorum was not present. So it is the responsibility of the company secretary to ensure that while taking the decisions, sufficient quorum is present in that particular virtual meeting. And also, let me say that Section 173, the peculiarity is while you are sending the notice, you can send the notice by hand delivery, by a registered post, by a speed post, and by electronic means, but very surprisingly not by courier. And again, if you see the SS-1 initially, 1st July 2015 one, we have provided for the courier, but subsequently in the revised standard, MCA advised us to stick to the section and courier is removed. 175 does talks about sending the circular resolution by way of a courier also, but 173 is not prescribing the mode of dispatch by courier. Because of that, if you see SS-1, the agenda also was to be sent by post or by electronic means, not by courier. These are a few finer points, Ashwini. I thought I will bring it to the notice of the participants. Thank you.
Well said, Sudhagar. One more thing is there when you talk about the identification problem. I would like to share personally in one of our board meetings, there were 3 people whose name was starting with David. David Essie, David Atherton, David Hughes. And somebody said, I'm David. I mistook actually because normally, you know, with the English people, it is very difficult for them unless we sit close with them and observe them also. On the video conferencing, when it was actually happening, as you rightly said when he spoke, I was concentrating what he is talking about it. Ultimately, I mistook one of the David, instead of David Essie, I mistook David as Ulysses. I have actually written the minutes accordingly. Then I was pointed out it is like that. Then I realized. Next time I started telling him, please, whenever he says, I'm David, which David you are? I used to ask. That is one thing. So I just thought of sharing it with you. It is very valid point what you have written actually. And one more small question I wanted to ask Sudhagar. When you say any other electronics means, whether sending it by WhatsApp will be electronics mean?
See, this issue we have discussed, in fact, in Secretarial Standard meetings, but as on date, WhatsApp, if I am not wrong, at certain places, the regulator, if he is sending any notice on the WhatsApp, whether it is to be recognized or not recognized, still it is in the debatable issue. But according to me, you cannot send up the board meeting notice by way of WhatsApp at least. I don't think that is an authenticated mode of sending that. Electronic means that you have to send it as on date by email only.
Because why I asked this question is in one of the matter when one of the statutory auditor had an issue with one of the ROC where the ROC actually sent the notice by WhatsApp to him actually.
I know.
Then later on he
I'm
called
aware
him
of
up and he told, yes, says what we have sent is correct actually. You will not attend. This should be treated. That is what he said. That is the reason why I asked this question. Yeah.
See, Babala, I would like to say like this. After sending the email, sometimes it may so happen someone is not traveling and he has no access to the emails. So that particular notice, if you are sending it in addition to the email, if you are sending it to WhatsApp, that is a pragmatic view we are taking it for the sake of convenience. But legally, whether you can issue the notice only on WhatsApp, I have my own apprehensions about it.
Palani, what are your views on this?
Yeah, I agree with Sudhakar sir, because primarily electronic means is where you have the end-to-end system which is identified and a methodology of recording the transmission, which is apparently not very secured with WhatsApp or cannot be authenticated. So I think the right way and the right approach would be that if you are sending it through email and for some emergency, you have to parallelly send it on WhatsApp or any other such maybe media, electronic media, and consider it to be communication rather than a compliance of the secretary standards.
Somebody has actually
One
put
more
up
thing
here.
also is, one more thing, Bala, is that as per SS-1, the notice and all other backup papers of the board meetings have to be preserved
Yes. Yes.
for a minimum period of 8 financial years.
Yeah, in
So
this,
WhatsApp notice is also not correct according to me.
in this respect, somebody has actually put up a small note here. You can have the record of the notice sent through the WhatsApp due to the new features of the disappearing messages. Anyway, what you said is correct. Today,
Yeah. And basically, see, when we send the notice, there should be proper tamper-proof proof, which can be tempered. WhatsApp has that possibility. That is the reason we had discussed earlier also. It can't be taken. It will be questionable. That is the reason. Because it was always argued that blue tick shows that the person has received and read and all that. But it can be possibility of tampering, and you should have tamper-proof record of that sending. And that's why I think it's a correct view that we should not send it.
somebody has put up a view there. They are not talking about the MCA, they are talking about the courts. They say courts have recognized sending the WhatsApp through the WhatsApp acceptable. Therefore, WhatsApp is also a accepted mode of the sending mail. WhatsApp screenshots can be taken for record purposes. That is what he is actually saying. And again, somebody say, I remember the year 2021, Supreme Court also made a judgment on the WhatsApp message. Court has accepted the legal notice through the WhatsApp. Then board notice should also be acceptable. That is the view. But as Sudhakar and
we will tell that Mr. Manish, will you be taking risk of sending that way and keeping record? That is the point actually. When the things is not judicially settled or accepted, it becomes risky to take that. So we are forming that opinion that it is not advised. But if you want to take a risk, it's the choice of the company.
Yes, go ahead, Ashwini.
So we move to section 174, which talks about quorum for meetings of board. So it is very clearly defined what would be the quorum for a board meeting. It is 1/3 of total directors or 2 directors, whichever is higher. Directors who are participating via video audio conferencing will be counted for the purpose of quorum. If in case there is no quorum, directors can only call meeting for filling the vacancies or calling a general meeting. If 2/3 or more directors are interested in any item during the board meeting, minimum quorum will include 2 non-interested directors. Adjournment due to lack of quorum. If quorum is not met, meeting shall be adjourned to same time, same place next week. If the adjourned meeting is falling on a national holiday, then the next non-holiday, except otherwise provided in the articles of the company. So now we move to a secretarial standard. So section 11810 of company.
Ashwini, again, 1 or 2 final points in 174. If you can go back to the previous slide. See here, as far as the quorum is that it says that if the board meeting got adjourned due to lack of quorum, then the adjourned meeting is to be to a next non-holiday, that is because of the national holiday. That means if the quorum is not there, it has to be adjourned to the next week, same time, same place, blah, 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 and all. But that day should not be a national holiday. Surprisingly, Companies Act is not objecting for holding a board meeting on a national holiday. Again, the same thing in the SS. Initially, we said that board meeting is not to be held on a national holiday. But subsequently, while approving the standard, ministry said no, board meetings can be held on, because this is as per the section, there is no bar on that thing. Similarly, adjourned board meeting cannot be held on a national holiday, but that adjournment is only for lack of quorum. That means if the board meeting got adjourned for any purpose other than for lack of quorum, those adjourned board meetings can also be held on a national holiday. Okay. Yeah.
So now we move to Secretarial Standard 1. So Section 11810 of Companies Act requires every company to observe secretarial standards with respect to general and board meetings specified by Institute of Company Secretaries of India and approved by the central government. The Institute of Company Secretaries has constituted the Secretarial Standards Board for formulating secretarial standards. Earlier in the Companies Act 1956, it was recommendatory in nature. However, by official gazette on 2015, secretarial standards have become mandatory and binding on all companies. So applicability of the standards, it is applicable to companies incorporated under special acts as well, such as banking companies, insurance companies. In case there is any inconsistency with the secretarial standards, the special acts shall prevail. The standards are in conformity with the provisions of the Act, and wherever subsequent amendments of the Act are there, standards become inconsistent and Act shall prevail. In case there is any variation in the provision of the applicable laws and standards, stricter provisions need to be complied with, applicable to meetings of Board of Directors and to committee meetings constituted under the Companies Act. Secretarial standards are not applicable to one-person company and Section 8 companies, only if it has not committed any default in filing its financial statements or annual return with the Registrar of Companies. We move to authority to summon the board meeting. So any director can summon a board meeting. A company secretary or authorized person convenes the meeting upon director's requisition in consultation with the chairman, managing director, or whole-time director, if applicable, required, unless articles otherwise provide. Chairman can adjourn a meeting at any stage, provided quorum is present. Majority of directors do not object for reasons other than quorum not being present.
So here it may be noticed that if you see the Companies Act, the chairman has power under the Companies Act to adjourn the meeting only for lack of quorum. Otherwise, as such, chairman is not having any power to adjourn the meeting. Whereas SS-1 has given that power to the chairman for adjournment of the meeting for any other reason also, provided majority of directors are not objecting to such adjournment. Yeah.
The time, place, mode, and serial number of the meeting. So it is mandatory to note that every board meeting must have a serial number. Meetings can be held at any time and place except national holidays. The notice that is given for the board meeting has to specify the venue, that is, example, registered office for meetings with electronic mode participation, and recordings of proceedings must be made at the specified venue. Meetings adjourned for lack of quorum cannot be held on national holidays, as we discussed, and directors can participate via electronic mode unless restricted by law or the chairman.
Ashwini, sorry.
Yes.
Yeah. So for Sudhakar sir and Bala sir as well, this was one thought I always had, that let's say it's a private limited company, there are 2 or 3 directors, and they happen to be at a club on a Sunday. And then they decide that, okay, let's call this as a board meeting and take it up. How should we consider, or what should be your views?
Actually, you would like to answer? Should I answer it?
So then secretarial standards will not be followed in that case. The notice and everything. Earlier would have been possible. I don't think now it is possible.
Yes, see that we can hold board meetings at a shorter notice. Okay, you cannot do away with the notice. Suppose, say, for example, if the 2 directors or 3 directors of a private limited company, they are sitting in a restaurant, they want to hold a board meeting. Ask that club or restaurant wherever you have business services, just prepare a small notice. Whoever is the director authorized, he can sign it, or the chairman of the board, if there is there, he can sign it. And after that, as far as the agenda is concerned, again the same thing. You can have it with the consent of the majority of directors presented. I mean, okay, the majority of directors, you can hold the meeting at a shorter notice, and you can circulate agenda also at a shorter notice. So there is no problem as such. In fact, there was long before, I still remember one question somebody asked me. Suppose the 3 directors, Vallari, you said they met at a restaurant. But suppose the 3 directors were in a flight, and while they were discussing, they thought that a decision to be taken, why can't we hold a board meeting during the flight itself? Can it be done? Again, the same thing. Answer is yes, you can, provided you will be able to issue a notice. So that notice, suppose, say, for example, if the flight is having a Wi-Fi facility and the chairman of the meeting is there, the chairman can issue the notice by himself by way of electronic board. So according to me, it is doable situation.
I totally agree with Sudhakar sir that it's not prohibited. It's only the requirement of applicable compliances you have to ensure, which is to just have a formal notice of the meeting, to circulate agenda, and where agenda means whatever topics that you propose to discuss, of course, with the approval and consent of majority of directors, and this could be doable. So I totally agree with you, Sudhakar sir.
So, Ballari, one more precaution what we have to take is, as whatever I have mentioned so far is as per the company law provisions and the secretarial standards. Shorter notice, all these things are doable. But you have to also see your articles, especially in case of a private company and a closely held public company or joint venture company. Normally, you do have restrictions as far as the issue of notice is concerned, the modalities of issue of notice is concerned. So, subject to the articles, whatever we said, I mean, that is doable.
Yes,
So there was a
absolutely.
question that is there any minimum timeline for a meeting? So I don't think there is a minimum timeline, like at least 24 hours notice should be sent, that nothing is mentioned. So there was a question that was raised.
No, there are many companies, they send a notice at 10 o'clock, they hold a meeting at 11:30, many private companies. So there is nothing like that. You have to give only a minimum time or something like that. When you say shorter notice, it is when the subject to availability and the concern of the people. Yes, if the shorter notice is already issued, you take it. And another thing here, it is also a practice. Or the shorter notice also taken. The shorter notice concern is actually recorded. Probably they prepared one sheet, take everybody's signature for the shorter notice concern. It is put on record. And even
So
when
there's
issue,
one person who's consistently raising hand. Should we allow Mr. Shankar?
No, raising the hands, we said we'll allow at the end.
Okay.
So let them put in the this thing, chat box, we'll answer. At the end, we'll take up the questions. Yeah.
So this part we have discussed that notice can be sent by hand delivery, speed post, registered post, fax, email, or other electronic means. It is to be sent to director's registered post or email address. Directors can specify a preferred delivery method. Proof of sending and delivery must be maintained by the company. Who issues the notice? It is the company secretary or an authorized person, authorized director or a person if no company secretary is appointed. What are the details required in the notice? The serial number, day, date, time, and full venue address, information on electronic mode participation, contact details for confirmation. The notice shall ask directors to confirm if they will participate via the electronic mode. If no response is there, physical attendance is assumed. Timing of notice, minimum 7 days before the meeting unless articles prescribe a longer period. Additional 2 days added if sent by post. Adjourned meeting notice. Notice must be sent to all directors, including absentees from the original meeting. 7 days notice unless adjournment date was pre-decided. Sir, I have a question here. Suppose, as we have said, adjourned meeting can be held 1 week after, like 7 days, same time, same place. So it is assumed that the adjourned meeting can happen after 7 days. Can the articles otherwise provide that the adjourned meeting can be done as per the requirement? And is there any timeline? Can it go beyond 1 month that an adjourned meeting is going to be held? If the articles provide.
See, without uh, overriding the Companies Act provisions, as per Section 6, you cannot override the provisions of the Companies Act.
Okay.
Okay. Over and above the Companies Act, you can do it, but you cannot override it. Say, for example, if it provides a minimum of 7 days, then you can do beyond that, but you cannot do less than that. So one has to be very careful while doing it. You should not land up in a situation where you are overriding the provisions of Companies Act.
So in this case, it will
Okay.
override, sir, right?
Yeah.
Agenda. So agenda shall outline the business that is to be transacted at the meeting, and notes on agenda shall provide detailed information. Timing for agenda delivery must be provided at least 7 days before the meeting, unless articles specify a longer period. Can be sent by hand delivery, speed post, or registered post, email, or other electronic means. It is to be sent at director's registered postal or email address. Then directors can also specify their preferred delivery method. Proof of sending and delivery must be maintained by the company, and notices, agendas, and notes must be sent to both original and alternate directors, sent to the address registered with the company. So while doing secretarial audit also, we are checking all the proof of sending and everything. So that has to be maintained by the companies.
Yeah, Ashwini, there is a recent amendment to this, right? Maintenance of proof of delivery.
Regarding like
No, now this proof of delivery of notice, it needs to be maintained for a minimum of 3 years. It's the requirement, right?
yes. So that is what in secretarial audit during the year, that is a requirement that we have to see the proof of sending the notice and everything, minutes and everything.
Okay.
So handling UPSI. So items of business considered UPSI may require shorter notice. So UPSI is defined under PIT regulations, SEBI PIT regulations like financial results, declaration of dividend, changes in capital structure, changes in KMP. So such type of businesses may require a shorter notice. In that case, consent is required from a majority of directors, including at least one independent director. Obtaining general consent for shorter notice on UPSI at the first board meeting is allowed, or whenever there is any change in directors. For this, what we understand is that there are 9 directors in a company and 5 have given their general consent at the beginning of the year to give notes on items of agenda which are UPSI at a shorter notice. If suppose a new director is appointed, consent from the new director to circulate such agenda items at a shorter notice can be obtained individually. If this director gives his consent, no fresh consent is required from the board. In case this director dissents or does not give his consent, fresh consent should be taken from the board. Any questions regarding this?
Yeah, I think that is fine. And it is very clear. It is.
The circulation of supplementary notes is allowed before or during the meeting with chairman's permission and majority consent of directors present, including at least one independent director. Each business item must be supported by a detailed note, including proposed details, material facts, implications, disclosure of any director's interest in the proposal, draft resolution for items needing resolution, serially number or serially number of all agenda items for ease of reference or cross-reference. For urgent business, notice and agenda can be given at a shorter notice if at least one independent director is present. If no independent director is present, then decision has to be ratified by one or the majority of directors. Also, it is mandatory to mention in the notice that the meeting is to be held at a shorter notice. Frequency of
just 1 minute. Actually, please go back to the agenda slide, yes, previous slide. You see that another thing I would like to bring to the notice of participants is about drafting the agenda. Drafting the agenda is again an art, and it is the responsibility of the company secretary to draft the agenda as comprehensively as possible. Most of the times it happens, whether we like it or not, what we do when we are preparing the agenda, we pull out the previous agenda, and to a large extent, we do the cut pasting business only. But even in the cut pasting also, one has to be very careful, number one. Number two, wherever possible, because a company secretary has to remember, realize one thing, that the board can take decisions. The responsibility of the board is not only to take the decisions, but to take informative decisions. That informative decision board can take only based on the information what they have been provided with. Several times it happens that whenever I interact with the directors, especially in the Institute of Directors where I go as a faculty, some directors who are already on the boards, they say that the company secretaries does not provide them the sufficient information. Then they have to ask for the information, then they will be said by them orally they give some information. So it is the right of a director that unless until he is satisfied with the information provided to him, he can always say that he will not participate in the board meeting unless until he has been provided with sufficient information. So as an independent director, it is his right. And suppose if the company secretary is still persistent for whatever the reasons it is, he is not providing sufficient information. That's why in the independent directors meeting, one of the mandatory businesses what the IDs have to transact as per Schedule 4 is about the flow of information. Whether the information is being provided to the independent directors sufficiently or not. If it is not being provided, then they can they can discuss in the independent directors meeting and take up with the chairman as far as the agenda items are concerned. They are not satisfying the way it has been drafted. In fact, in one of the companies, uh, I have been told that this kind of an issue has come up. The company secretary asked me how he has to proceed with, because he himself is not getting sufficient information from his colleagues. So in such case, obviously the company secretary, he cannot, if he himself is not having sufficient information, how can he furnish that in the agenda papers? That point of time, he has to seek the intervention of the chairman or the managing director, whoever it is. Yeah.
Sir, you have rightly said, and this is one important role or skill as a company secretary we should develop is to understand the business needs, to understand the perspective of directors, that what kind of information they will need at the meeting. So what is the important information, and then of course to coordinate with the relevant internal departments or people, because sometimes the internal management people or those who have to present the data are not very comfortable sharing everything. But once we know that what the directors expect and what would they need to make that decision, I think that puts us in a stronger position to get that appropriate information and place it before the board members.
The same point of time, Valari, as you rightly said, I also will say that if the company secretary is approaching the chairman for his intervention, every time, then the chairman will get chased off, and then what for the company secretary is there. So it is a high time even for the company secretaries to put their foot down. Unless until they get sufficient and proper information, they will not take up the agenda item. Let the concerned HOD or whoever is the person sponsoring that resolution, let him go to the chairman and say that the company secretary is not taking up the item in the board agenda. That point of time, the company secretary can say that, look, I am not satisfied with the amount of information what I have been provided with, because I am answerable to the independent directors. So a time has come up that company secretaries have to take a firm stand.
Yes.
Then only they will be respected by the independent directors and subsequently even by the internal directors also. But of course, definitely at point of time, the company secretary require a lot of other skill sets like your communication abilities, your diplomatic skills, all those things you have to do it. Yeah.
Frequency of board meeting, minimum 4 meetings each financial year will have to be, each calendar year will have to be held. Maximum interval of 120 days is allowed between any two consecutive meetings. About the first board meeting, it has to be held within 30 days of incorporation. Further, the subsequent meetings must adhere to 120-day interval rule. There is an illustration. If a company is incorporated on 15th of June, the first meeting should be held with.
Bala sir, please go on mute.
The first meeting should be held within 30 days. Say it is held on 10th of July, then there is no need to hold a meeting again in the July to September quarter. It would be sufficient if one board meeting is held in the October to December quarter. For one person, small, dormant and startup private companies, at least one board meeting in each of half of the calendar year is required, and minimum gap of 90 days between meetings. The adjourned meetings interval is counted from the date of the original meeting. And for the committee meetings, the committees can meet as often as required by law, prescribed authority or board stipulations. For independent directors meeting, there should be at least one meeting per financial year without non-independent directors or management to review the performance of non-independent directors, the board as a whole, chairman, and flow of information between management and the board. A meeting of independent directors is not a meeting of the board or a committee meeting. Therefore, provisions of SS-1 shall not apply to such meetings. A record of the proceedings of such meeting, however, may be kept. The company secretary's role is the company secretary assists in organizing the independent directors meeting if requested.
Of course, though the issue is settled down by now to a large extent as far as the independent directors meeting is concerned, as Ashwini has rightly mentioned, it is not a board meeting or a committee meeting, so SS-1 is not applicable. But certainly, several times this question comes that whether a notice is required for independent directors meeting, whether an agenda is required for independent directors meeting, whether attendance is to be taken, whether sitting fee can be paid or not, whether minutes are to be drafted or not, whether the minutes are to be circulated to the other directors. These are all several questions used to come. The answers to that question is, though legally, what are the modalities of independent directors meeting, though it is not there. But if we question ourselves, we can find out the answers for that. First is whether a notice is required. Without a notice, how the independent directors will come to know that there is a meeting? How you will establish to the secretarial auditor that a meeting has taken place on a particular day? So it is, you have to formalize this. Holding the independent directors meeting is not an informal meeting. It is a statutory meeting. It is a formal meeting. And you have to establish, it is a legal meeting also, let me put it this way. So though the legal provisions have not been clearly spelled out, you have to comply with that. So notice is very much required. Similarly, agenda is required or not? Yes. What are the points of discussion? What is there? You have to have that thing. Third, whether attendance is to be taken. Without taking an attendance, how can you prove that a person has participated in the meeting or not participated in the meeting? So very much attendance is required. Sitting fee can be paid or not. In the last webinar, we had discussed about this. The 197.5, the board can decide to pay the fees for any other purpose. So sitting fee can be paid. It is the discretion of the board, but independent directors cannot demand a sitting fee as such. Finally, whether the minutes are to be drafted, yes, you have to have a record of the discussions what have taken place. However, the way we draft the board minutes and the committee minutes, you need not draft it in the same way. There may be some kind of a bullet points or some kind of a discussion point, something like that, but there should be a record, definitely. Whether those minutes are to be circulated at the next board meeting, not required, because sometimes it may so happen because the independent directors meeting is to be held without the presence of any executives or executive directors. That's why once the meeting takes place, the lead independent director, or whoever is the chairman of that particular meeting, he can share that draft, that what's called the recordings of the proceeding. Recording means the minutes, you can say, with the chairman. And obviously, the company secretary is custodian of all secretarial records. So he is the person who is supposed to keep it. And at the same point of time, whether the secretarial auditor has a right to inspect the minutes, obviously he can have a look at it. Now, question comes in one of the secretarial auditor when he asked the company secretary said that we have not maintained the minutes for the independent directors meeting. Legally, it is not required. The secretarial auditor was going to qualify that report that the minutes have not been maintained. Again, this is a issue which need to be sorted out. But as I mentioned to you, though it is, required to have that minutes, some kind of a recording. But according to me, secretarial auditor need not qualify the report because the minutes of independent directors meeting is not maintained. Yeah, Vallari, Bala, if you want to add anything, Deepti, I don't know whether you are there or not.
Yeah, of course, I'm there.
Yeah, please, you may also do it your
Yeah.
points.
I think you have covered everything. Only because even the who can inspect that minutes, that also you have covered. So I think you have covered every point.
Sudhakar, your
Okay,
point is
fine, great.
absolutely correct. Only thing is, many questions arise whether sitting fees is to be paid or not. That also you are very clearly telling. It is up to the company to decide. If they want, they can actually pay. If they decide not to pay, that is something different. It is the decision they have to take. But law does not prohibit in paying the sitting fee because it is as good as the committee meeting because the directors are meeting. That is there. You have given ample.
In fact, recently, another question has come up that statutorily only one meeting in a financial year is required. Can a company have more than one independent directors meeting? Answer is yes. In fact, rather it is advisable to have more than one meeting because one meeting in a financial year is not sufficient according to me for bigger companies. In case of Reliance, we used to have, when I was there, we used to have an independent directors meeting in every quarter. That means 4 meetings in a year it used to take place. Because a kind of big company, you cannot have just one meeting in a year. But smaller size companies, yes, one meeting is sufficient also.
No, you have rightly said, sir. At least one meeting is prescribed, so there is no prohibition to have more meetings. And the one point which you absolutely brought out was that while there is no mandate for compliance of secretarial standards, there is absolutely a requirement to have some evidence of holding that meeting because it is statutorily required. So a notice is required. Maybe one of the independent directors would have sent it to the other independent directors if the assistance of CS is not taken. But such kind of evidence is required. And while those minutes may not be circulated to the other board members, at least a noting that such and such date the meeting of independent directors was held to be recorded in one of the subsequent board meetings is, I think, an important step.
Absolutely. I agree with you, Vallari.
Yeah. Meanwhile, there are many questions relevant to what we discussed. So I think better we take it parallelly. One
Sure.
question, Ashwini, was that as regards the applicability of secretarial standard to committees. So whether it is applicable, they have asked risk committee, but you can clarify voluntary committee and statutory committee. It is applicable to both or only statutory committee. Means committee required by statute.
It is applicable to statutory committees.
Applicable statutory committees, the committee required under Companies Act. Also to the committee required under other statute, it is applicable, like for suppose mutual fund or anything.
No. It is only the committees which are required to be constituted under the Companies Act. Technically say that it is not applicable to risk management committee, which is to be constituted under the listing regulations.
Yeah.
Any other committees, say for example, NBFC companies have to constitute certain committees under the RBI Act. Those committees, technically SS-1 is not applicable to that. But
So
my advice is that when you are complying, yeah.
So your answer is only Companies Act, not even LODR.
Correct. Not even allowed.
But there is one more thing is
But
that
you said that, sorry, Mr. Bala, I interrupted Sudhakar. You are continuing. You can add that sentence you wanted to tell.
No,
Yeah, what I was trying to say is it is only advisable that
Yes.
whenever you are complying for certain committees, you cannot say, ki, by okay, for 4 committees I will comply with, and for the 5th committee I will not comply with. The advisable as much as possible, wherever, suppose if your company is NBFC company, the committee is what you are constituted as per RBI regulations, or insurance company as per IRDA regulations, if it is a telecom company as per TRI regulations, please do comply with them as far as the SS is concerned.
It will help you only actually.
Correct.
Sure.
Correct.
one more point, Sudhagar, when you said, in case of the NBFC company, even the private companies can be registered as an NBFC company. And one of the requirements of the RBI for such private companies, you need to have the audit committee constituted under the RBI regulation, even for the private company, if it is an NBFC company. But the RBI regulation itself says that while constituting the audit committee, the provisions of the Companies Act will apply. Very categorically, they are saying. In such a case, even if you are constituting the audit committee in a private company, because of the NBFC company as per the RBI regulation, because it is constituted as per the provision under the Companies Act applicable, one has to comply with it. That is the point I wanted to add.
Okay. There is another question. What is the minimum
Yeah.
period?
We'll do one thing. We'll run through the questions. We'll take, I think. Let me run through the question from the beginning. So let us take, I think.
All we have answered.
Yeah.
This straightway coming to that Vaidyahi. What
Yeah.
is the minimum period of the notice should be given to director in case of shorter notice for board meeting by video conference?
See, shorter notice, there is no time prescribed as such, unlike AGM. Okay, because in case of general meeting, you have to have that proxy appointment and all. As far as the board meeting is concerned, with the consent of majority of directors, you can hold the meeting at a shorter notice. Even 1 hour notice is sufficient, half an hour notice is sufficient. It all you have to see the practicalities. How many directors you have? Suppose, say, for example, you have 3 directors who are all in the same vicinity. About an hour's notice, they may come physically or they may attend the meeting through a video conferencing.
Yeah,
So there is
just
no timelines as such are given, but only thing is you have to see the practicalities of conducting the meeting. That's it.
and don't miss to check your article provision, please. Yeah.
Correct. Absolutely. And at the same point of time, Deepthi, also let me clarify that in the notice, you have to clearly mention that this meeting is being convened at a shorter notice. Similarly, while you're drafting the minutes also, in the header, you have to say meeting convened at a shorter notice. And in the body, you have to say that with the concurrence and consent of the directors, majority or unanimous, this meeting is being conducted at a shorter notice. That also you have to record it in the minutes.
Yeah. Thanks.
Absolutely.
Sudhagar,
Yeah.
somebody has put it, standard of ICSA generally for the members only. However, in SS-1 find that the standard also give prescription for the directors. For example, he shall have his comments in the draft minutes within 7 days. Is this correct? Is the director is liable to comply SS-1 if it is made mandatory? Why can't they, such a requirement is actually incorporated in the Companies Act 2013 itself?
Sir, secretarial standards are not for the members of the institute. Secretarial standards are for the stakeholders. Number one. Number two, I reiterated in the beginning itself that SS-1 and SS-2 are part of the Companies Act. It is a law. It is not for the members of the institute only.
Okay, you answered it. If the notice can be sent to the authorized director, if the notice be to all the director, does he send the notice himself or he himself or the authorized director? If notice is sent by authorized director, is notice of BM to all director, does he send notice to himself as he himself is authorized director?
Yes, he has to send to himself also. Because suppose, for example, tomorrow if the secretarial auditor says that if a director is signing the notice and he has not been delivered that notice, can you say that okay, I have been given this thing? So even if you are also a director, And you have to prove that a notice has been served upon you also.
What is the good practice for the circulation of the document having UPSI, etc., to be discussed in the ensuing board meeting?
See, always UPSI information, though you don't need to circulate along with the agenda as such, but you don't need to table that item. Always, at least you have to circulate that UPSI items 24 to 48 hours before the meeting. The reason being, when the directors are attending the meeting, they have to have sufficient time to browse through the papers. Say, for example, quarterly financials or year-end financials, no doubt it is a upsee. And if you send it 7 days before, there is always a chance of getting that leakage of that information. So for that particular purpose, you don't need to send along with the agenda papers. But at the same point of time, you have to give sufficient information to the directors concerned to go through the figures. And if you simply table the items, how they will go through that? So what normally we do is that while you are circulating the unaudited or audited quarterly or year-end results, you can what's called block one or two key figures, because the suppose the sales figure is there, the raw material consumption or some other information, whichever is the key, that you hide it. Rest of the things you can always send it. What is the problem? So you always, it is advisable to circulate the information 24 or 48 hours before, if not more. At the same point of time, as I mentioned, still if you think that some information is a very key, suppose 10% or 15% of the information, you can hide that. Remaining, you can send it to the directors so that they will be able to go through the remaining information, come prepared for the board meeting. They can easily correlate the remaining 10-15% of information with the 85% information which you have already provided to them.
What to do about complying with the independent director meeting in a year if there is only one independent director on the board and public sector undertaking company cannot appoint IDs own to their own, and to do in such a cases, can a meeting of one ID is possible?
See, one person cannot meet at all. And similarly, wherever the independent directors have to mandatorily appoint, you have to appoint two directors minimum, if not more. Out of the two directors, instead of two directors, if the company is having only one independent director, that company cannot hold the independent directors meeting and there will be a non-compliance to that extent. If there is a secretarial audit is there, secretarial auditor can qualify the report to that extent.
Can CS attend the independent directors meeting?
Provided he has been asked to attend, independent directors, because in Reliance we have been asked to attend, and sometimes it may so happen in the beginning of the meeting you will be there. Wherever the independent director wants to discuss certain information which is confidential, they can ask you to please leave them or to recuse yourself so that you can come out of the meeting. Sometimes it may so happen they may start the meeting and ask the company secretary to join subsequently or other executives to join subsequently. In fact, in Reliance, what used to happen was the independent directors used to say, depending upon the agenda items, we used to invite some senior executives to be as a standby. And then the independent directors used to ask the company secretary, okay, now let us take up item number one. Let us invite so and so person. So he will attend the meeting. He will make the presentation, whatever it is there and all. That's how it happens. So it is the prerogative of the directors to whom to invite, to whom to call inside, and to whom they have to ask to excuse him.
Please confirm whether SS-1 prohibit to send a shorter notice for board meeting.
Please read SS-1 clearly.
If the company is obliged to give a copy of the recording of the proceeding of the meeting in addition to the shared signed minutes, and within how many days of conclusion of the board meeting?
Okay, this is a good question. In fact, I think Ashwini is yet to come to that minutes circulation and all. When she comes there, that time we will discuss this point.
In case there are 4 directors, but 3 are in the restaurant and the chairman served the notice only to 3, will it be a valid board meeting?
It will not be. When you are circulating the notice, you have to circulate to all the directors, number one. Number two, you have to talk to the fourth director also. Suppose that fourth director might not be there in that particular city or town. He might be there some other town. So you have to check with him that, look, we want to conduct a meeting at a shorter notice. This is the agenda item going to be. Are you in a position to attend the meeting through a video conferencing? So if he says it is fine, or alternately, he may say that, look, you may please grant me the leave of absence. Other 3 of you may meet. So they can discuss it. And after that, whatever the draft minutes and other things are there, Ashwini is yet to come to that place in SS-1. Like that, it is to be circulated, the draft minutes and all.
An authorized director send the board meeting notice. When the company secretary has the company secretary, is it the valid notice?
See, wherever a company secretary is there, it is preferably the company secretary who has to sign the notice. If the company secretary is not there, the chairman himself can sign the notice. If both of them are not there, then any person authorized by the board has to sign the notice. So these are the things which are very clearly, explicitly provided in the SAS standards, explained in the guidance note. Why, after almost 10 years of SS-1 in implementation, if we are still asking this basic elementary questions, it is not correct.
In case of the private company, there are serious differences among the 3 directors. One director did not receive the notice and agenda papers, but he is recorded as a present. He does not receive the notice. No discussion. Not even no minutes are shared. What remedies he has? Should he approach ROC or NCLT?
See, to reduce these kind of litigations, only SS-1 has been made mandatory for all the companies. Several times I have given examples also, like wearing a seat belt, how the way it is important while you're driving a car. Similarly, while holding board meetings or general meetings, complying with SS-1 and 2 are mandatory. Several times this question used to come. Why for small private limited companies, SS-1 is to be made mandatory? If you see, Bala, the ROCs actually adjudicating proceedings or adjudication orders, most of the times these are private companies only which are getting penalized, for non-compliance of SS-1. Actually, these are the companies, if you issue the notice, if you maintain the proof of dispatch of notice, if you draft minutes, if you send that what's called a draft minutes to the directors and maintaining proofs of that and all those things, it is very easy to establish. All these allegations which used to be there in the good olden days, they will not be there now.
What is the venue of the board meeting if it is held at the flight?
You write that very clearly that, that during the flight, a board meeting, it was the directors have decided, considering the urgency of the matter, and in flight number so and so, between from this place to this place, the meeting had taken place, so and so have attended. You write in the minutes very clearly everything. You are not doing anything which is not what's called as accepted by law. You are doing it perfectly within the legal provisions. Please do it.
Out of the 7 agenda items, the board passed the resolution in relation to only 4 agenda items. Can the board adjourn the meeting for remaining the 3 agenda items?
Yes.
As discussed previously, board meeting can be held in the national holiday.
In fact, let me say this also, Bala, that since we are talking about adjourned meeting, there used to be always a question that can a sitting fee be paid to the adjourned meeting? Say, for example, that today the board meeting had taken place because of sufficiency, or that because of the time lag or whatever it is, the meeting got adjourned for whatever the reasons it is. Can we pay the sitting fees to the adjourned meeting also? Technically, answer is yes. Again, same thing, 197 subsection 5, if you take it, the board's discretion, board can also decide to pay the sitting fee for adjourned meeting also. And rightly so, because the directors are spending time for attending that meeting and other things. Okay.
You are absolutely right. It's a very practical question, Sudhagar. In fact, the company where I was there, the adjourned meeting used to take place the different day and we used to pay the sitting fees. As discussed previously, board meeting can be held on a national holiday. Is this slide is it denied? So what can we conclude? No, he explained the national holiday matter very elaborately when he was discussing between the two sections. Board meeting on a Sunday is illegal under Companies Act 13.
Yes. You
Okay,
can even have AGMs also these days on a public holiday.
Okay, then shorter notice we actually discussed. One question of the board meeting number should be cumulative or not, to say for financial year 22-23, 4 meeting were on 23-24 about meeting number 5, or it should be 146.
It depends upon your convenience. You can have a serial number right from 1, 2, 3, 4, or you can say first board meeting of the financial year so and so. Like that also you can do it. But as far as the paginization of the minutes are concerned, they should be 1, 2, 3, 4 onwards. There should not be a break at all. Some people, what they do is whenever they are getting it bounded, they used to have the new page numbers, which is not correct. And the ROC can penalize those companies for not doing the paginization.
I think somebody has put a information, I think. I've been informed by a senior advocate.
I think, Bala, that why can't Ashwani complete her presentation before you take further questions?
Okay.
Yeah. Otherwise, we may that continuity may be lost in between.
Okay.
Yes, Ashwani.
So for the quorum requirement is that the quorum must be present throughout the meeting and not just at the start. Directors with interest cannot be counted for the purpose of quorum, except in private companies after giving their disclosure. No business can be transacted if the number of directors falls below the minimum specified in the articles. Directors can act only in case to increase the number of board of directors or summon a general meeting. A director is interested if he is involved in contracts with a body corporate holding more than 2% of the paid up share capital, or as a promoter, manager, or a CEO, or a firm or entity where they are a partner, owner, or member. Interested directors cannot be present physically or electronically during discussions or voting on related party transactions. If interested directors exceed or equal 2/3 of the total strength, the remaining directors, at least minimum 2, shall form the quorum. Directors participating via electronic means are counted for quorum except for items requiring physical presence.
Sometimes it may so happen that the non-interested directors may not be forming a quorum. Say, for example, they may fall less than 2. That means only one person who is not interested, he cannot form a quorum. So that point of time, what you have to do? So you have to refer the matter to the shareholders for their approval. That is the only way. Because, or alternately, what you have to do, you have to increase the number of directors so that you have sufficient disinterested directors quorum. They cannot be have a interested directors cannot be the part of the quorum unless until it is a private company. After disclosure, yes, they can do that. Okay.
The quorum calculation shall be 1/3 of the total strength or 2 directors, whichever is higher. If articles specify a higher number, then you have to follow the articles. Adjournment due to lack of quorum, this we have discussed. If quorum is not present, adjourn to same day, time next week, unless it's a holiday. If quorum is still not present at the adjourned meeting, then the meeting shall stand cancelled. Committee meeting quorum. Quorum for committees is as specified by the board. If not specified, all members must be present and follow other laws if applicable to the committee. In case of attendance of meeting, every company has to maintain an attendance register for board and committee meetings with serially numbered pages. If in loose leaf form, the register must be bound every 3 years. Details to be included are the serial number, the date, committee name, meeting place, time, director name, signatures, mode of presence, including electronic. Directors participating electronically are deemed to have signed the register if their attendance is recorded and authenticated by the company secretary, chairman, or authorized director. Chairman confirms participation, confirms electronic participation via roll call recorded in meetings. The register must be preserved for at least 8 financial years. After 8 years, it can be destroyed with approval of the board and kept in custody of the company secretary or an authorized person if no company secretary is appointed. So we do get a lot of questions on the attendance register if the directors are attending through video conferencing, but I think this clearly mentions how it is to be authenticated and kept for the purpose of audit also. So leave of absence for directors is granted only on request of the company secretary, chairman, or authorized person. A director's office becomes vacant if they miss all board meetings for 12 months with or without leave. Roll call, we have discussed this earlier that during the roll call, every director participating through electronic mode should state for the record the following, namely the name, location from where he is participating, that he has received the agenda and all the relevant material for the meeting, and that no other person other than the concerned director is attending or having access to the proceedings of the meeting.
Ashwini, here now, let's go back to the previous slide. Yeah, I think then the next is vacation of director. What is that? Next slide.
So we are giving example of how to calculate the vacation of director, 12 months.
Okay. Now let us go back to the previous slide then. Okay. So here, in fact, though we have discussed it, I think in last webinar, where I was mentioning about the alternate director. Suppose, say, for example, if the director is traveling abroad for more than 3 months, board has decided to appoint an alternate director for him. So question comes whether the notice agenda papers are to be sent to the alternate director or to the original director also. As I have mentioned in the last webinar, that for all purposes, the original director as well as the alternate director, they are directors. Whenever you are giving list of directors to any one, you have to give the names of both the directors, and in case of alternate director, you have to mention against his name, alternate director for so and so person. So alternate director is not a proxy for the original director. He is not a representative of the original director. So whenever you are sending notices, you have to send the notice to the original director also. But you don't need to send it to the place where he is going to be there. You have to send the notice to the address what he has given in India only. That is one point. Second point is whether it is a circular resolution, whether it is a board meeting notice, if he is a committee member, that notice, all the notices you have to send it to the original director also. Because for all purposes, as I have mentioned, he is a director and he is responsible for the conduct of the company also. Tomorrow, if something goes wrong, he will also be held liable. That's why he should be in the loop of what is happening in the company. Second thing, a question comes that whether he can attend the board meeting through a VC. When an alternate director has been appointed, the original director, for all the purposes, we can take it as if he is going to be in a slumber. So even if he is attending that meeting through VC, he requires, number one, the permission of the chairman. Number two, he will be attending that meeting only as an invitee. He is not attending that meeting in the capacity as a director. Because unless until he comes back to India and resume his position as a director, he cannot participate in the board meetings. He cannot participate neither in the discussions nor in the voting of the meeting. At the most, even if he is attending that meeting with the permission of the chairman, in the board minutes, you have to record that he is attending the meeting as an invitee only. And his name will be there in the list of invitees and not in the list of directors. Okay. Now the question comes, this vacation, a director office becomes vacate if they miss all the board meetings for 12 months with or without leave of absence. Suppose the original director is not coming to India for a period of 12 months, he is not attending any of the meetings. Whether he has to vacate the position? Answer is yes. Because if you read 167, nowhere that exemption has been provided to the original director. That means what? Once you appoint an alternate director, it is not in perpetuity. The original director can be in slumber. He has to come back to India once in a year at least, and he has to attend the meeting once in 12 months, either physically or through a video conferencing. But otherwise, he has to vacate the position. Yes, Ashwini.
Also, continuing from where you're saying the vacation of office of director shall begin from the first meeting from which he has not attended. So if he has attended a board meeting, last board meeting which was held on 28th of March, suppose, and the next meeting was supposed to be held in June, then his count for 12 months shall begin from June, and then we'll count for 1 year. If he has not attended any board meetings, then he has to vacate his office.
Several people count it from the last meeting attended, which is not correct. Several times we have clarified this also. It is the subsequent meeting which he was supposed to attend, which he could not attend. That is the time from there he has to take 1 year.
And it is also clarified in guidance notes also.
Correct.
Yeah, guidance notes has given very, illustrative example for all these matters. That is why Sudhakar has also been talking, even I have been also telling, guidance notes are excellently written by giving the appropriate illustrative things everywhere. I think people have to go through it to know the thing better. Yeah.
Next is the chairman. The chairman of the company is also the chairman of the board. If there is no chairman, directors may elect one among themselves as a chairman for the meeting. If he or she is absent, then directors present will elect a chair for the meeting unless articles specify otherwise. The chairman and company secretary have to ensure the meeting is properly convened and compliant with all the relevant laws and regulations, and the security and integrity of electronic participation, safeguarding confidentiality. The chairman encourages discussion and summarizes the sense of the meeting. If the chairman has a conflict of interest, a non-interested director conducts that item except in private companies post-disclosure. The chairman cannot be present during discussions or voting on related party transactions, physically or electronically. He ensures the quorum is maintained throughout the meeting and summarizes decisions after each agenda item. If votes are tied, chairman has a second or casting vote unless otherwise provided.
Ashwini, you said chairman of the company is chairman of the board. Whether chairman of the board is chairman of the company, reverse.
I'm not sure.
No.
See, chairman of the board does not become the chairman of the company automatically.
Yeah.
So if that in the board meeting, it is to be decided, Mr. So-and-so will be the chairman of the board as well as the chairman of the company. Then only you can say so, otherwise not.
Yeah. And there is no chairman of the company requirement as such, but this is the
Correct.
end actually that it is said that chairman of the company. So since
Customary and conventional.
this designation is created by the board itself, it's not by the statute, then that designation, because that will give the impression to the public that this person is the chairman of the company. Chairman of the board in Companies Act, chairman is only for the chairman of the meetings. So this is a very common mistake, even the promoters and businessmen are not knowing. So that's why I raised this question. Chairman of the company is not the position in the Companies Act, but it is created by the company or the board itself. Yeah, Ashwini, go ahead.
Yes. So passing of resolution by circulation. So section 175 talks about passing of resolution by circulation, as well as additionally annexure 1 to Secretarial Standards is also Secretarial Standards 1 states that which items can be passed through circulation. So every time whenever there is any circulating item, you need to refer to SS-1 to know whether this can be passed through circulation. So only urgent business can be approved by resolutions passed by circulation as valid as resolutions at board meeting. If 1/3 of directors request, the resolution must be discussed at a board meeting instead of being passed by circulation. Directors have a maximum of 7 days to respond, with an additional 2 days for resolution sent by post. And resolution shall be deemed to be passed on the last date for receiving the response, or if all the majority directors approve, then on that day where all the directors have approved the resolution. Past resolution must be recorded in the minutes of the next board meeting. Resolutions by circulation are valid but do not replace the requirement of holding regular meetings. Resolution passed when the majority of eligible directors approve, unless the articles specify different majority. Interested directors cannot vote on resolutions where they hold a significant interest. Draft resolution with necessary documents sent to all directors by hand, post, or electronic means must include business details, relevant facts, and how directors should respond, their assent or dissent.
Actually, 1 minute. The resolution by circulation. See, as we know that section 175 talks about resolution by circulation. That means wherever there is some kind of an urgency of the matter, and for everything you cannot convene a board meeting. So the Act has provided certain resolutions you can pass by circulation, unless until the Act prescribes that the resolution is to be passed at the board meeting only. Like your section 186 is there, section 179, if your resolutions are there, section 188 is there. These resolutions you have to pass only at the board meeting. In addition to that, SS-1, as Ashwini has rightly mentioned, there is an annexure A is there. Certain resolutions you are not supposed to pass by way of a circular resolution. So when you are proposing a resolution by circulation, you have to also provide that the draft resolution, the way you want the resolution to be passed, that draft resolution you have to attach it. If there is more than one resolution out there, you have to attach. Separate consent is to be taken. That means if there are two resolutions you are proposing to pass by circulation, that the directors have to be provided the signatures for both the resolutions separately. And surprisingly, as I mentioned to you, 173, though it is not permitting to send you the notice or agenda by courier, but 175 is providing that you can send the circular resolution by courier also. This section also provides that not less than 1/3 of the directors can ask the company to pass this resolution at the board meeting. That means, suppose if a company is having, say, 10 directors, 1/3 of that means, up to 4 directors can ask the company that this passing the resolution by circulation is not agreeable. They want that meeting, that resolution is to be discussed at a properly held board meeting. In such case, the company has to convene the board meeting mandatorily. Then question comes that once you propose a resolution by circulation, when the resolution is passed, and how many days you have to give to the directors to give their dissent or dissent, whatever it may be. Maximum number of days what you have to give is only 7 days. You cannot give it beyond 7 days. The rationale for this thing is because if you want to give more than 7 days, you can very well convene the board meeting itself by giving a 7 days notice. That means there is no urgency to pass the resolution by circulation. Why can't you convene a board meeting and then do it? So you can give 1 day notice. I mean, suppose you are proposing a resolution today, you can ask the directors to give their assent or dissent by tomorrow evening, by day after tomorrow evening, like that. The crucial question is when the resolution is passed, on which date? The date when you have received the majority, or the last date what you have given, or any other date. Say, for example, you have a company where there are 10 directors are there. So in the 10 directors, you have proposed a resolution, say on 1st of October, or maybe 1st of September. Say, for example, let us take it 1st of September, you have proposed it. And you say by 5th September, the consent is to be given by the directors. Now, On the 2nd September itself, 6 directors have given you the assent approving the resolution. So majority of the directors, the 10 directors, majority are obviously 6. Majority of the directors have given it on 2nd September. Can you take the resolution has been passed? Answer is no. So when can it be, when you have to take it? Because as I told you, 1/3 of the directors can always ask before the last date to convene a meeting to discuss that particular resolution. So if it is, unless until it is less than 1/3, you cannot take it by circulation. So on 3rd of September, one director has further given, but he has voted against the resolution. Now there are 7 directors who have voted on the resolution. 6 have approved, 1 has not approved, and 1/3 of the directors are now not there. Only 3 directors are there who cannot ask the resolution to be passed at the board meeting. So you can take that the resolution is passed on 3rd September, where 7 directors have voted. Suppose in the 7 directors, when they have voted, out of the 7 directors, say 4 directors have not voted for, only 3 have voted for, then the resolution is fallen. Okay, this is the provisions. If any questions are there, I am happy to take that.
Valerie, you want to add something?
No, I think Sir has elaborately covered, and this was precisely the example and thought even I had, that this becomes slightly confusing for every one of us, that whether it is majority who has approved can we consider, but still there could be 1/3 of the directors who could insist the resolution to be taken at the meeting. And so Sir has perfectly clarified when it is that we can consider it is approved, if it is majority of the directors who have voted, and then check whether the voting is in favor or against, and then see whether the resolution is approved or it's defeated.
Yeah,
And
you're
One
right.
thing, Vallari, is that section 175 also talks that the resolution which have been passed by circulation, that is to be recorded at the next minutes of the board meeting. Sorry, in the next board meeting. Is it mandatory? Answer is yes. Even if you have passed the resolution,
Yes.
but you have to also record it in the next
Subsequent.
board meeting. That means there should be an agenda item. It may not affect the validity of the resolution. By chance, suppose due to any reasons, if it is not taken up in the next agenda, though it will not affect the validity of the resolution, but it will certainly lead to non-compliance of the provisions of section 175 if you are not taking up in the next agenda item. Yeah.
You are very much right, Sudhakar. In one of the companies, it was so happened. They have not taken the circular to the next meeting. They have taken subsequent to the next meeting. ROC has penalized that company. That cases are also there. That is one. And second thing is coming to resolution when it is said to have been passed. Typically, what happens is the private company, there is a possibility because suppose there are only 3 directors are there and the 2 directors has approved. So you cannot say the majority has approved and it is passed because that one director still forms that 1/3 of the director. So you have to wait until the time and because he can actually demand a discussion on the board meeting. You have very well explained this, Sudhakar. Thank you. Yes, Ashwini, go ahead.
Next is about the minutes. Minutes have to be kept for all board and committee meetings as an evidence of the proceedings. Separate minutes book for board meetings and committee meetings have to be kept. It has to be maintained in physical or electronic form. Electronic form requires a timestamp. Minutes book must be kept at the registered office or other board approved locations. A uniform format must be followed for maintaining the minutes. Pages must be consequently numbered. Blank pages to be scored out and initialed by the chairman. Loose leaf minutes must be periodically bound to prevent tampering. No pasting or attaching materials to minutes is allowed. Signed and dated by chairman, all pages initialed and blank spaces scored out. Inspection of minutes. Directors have the right. Sir, I have one question. So a lot of times what happens is the scoring out thing and the directors are not quite comfortable in initialing that page if it is scored out. So we face a lot of difficulty in terms of secretarial audit where the companies come and say that no director is ready to. So when you score out, is it essential to initial that page as well?
Yes, it is to be.
Yes.
Technically, answer is yes. Because what they say is every page is to be initialed. So whether you have recorded something on the page or not, it is to be. And second thing, Ashwini, let me tell you, the chairman will never say no. It is I have to take the blame on our profession only that we are not able to explain to the chairman about the legal provisions are concerned. If you explain to them, certainly they will do it. Say, for example, several adjudication orders, what Bala used to always write the articles, most of them are paginization is not there. Pages are not initialed, pages are not scored off, or the chairman has not put the date himself. See, what it says is section 118 section plus erstwhile 193 also used to say is that the chairman has to sign initial every page, put his full signature at the last page and also date. So it is the chairman who has to put the date, not the company secretary. And now under the new act, he has to also put the place where he is signing the minutes. So even when we send the minutes to Mr. Mukesh Ambani and Reliance, we ask him to put the date and also the place. We put that thing with the pencil. This is the date. This is yet he does it. Why not? Chairmen are all educated people, and if you say, but these are the legalities and all, certainly they will do it. Suppose some people they may get cheesed off, some people they may not like what you say, but you have to have that persistence and perseverance to convince them. As a company secretary, it is your responsibility to do it. Okay. And similarly, this, in fact, for the last so many years, I say that several company secretaries have this bad habit of not making that page numbers. Always in the back of their mind, they say that if something goes wrong, I have to change the minutes. That point, if I do the page numbering today, I will be in problem. So most of the times it happens that before or after the secretarial auditor, they do the paginization. God forbids if there is an inspection in between and the pages are not numbered, most of the times it may so happen. Obviously, ROC will take it as a non-compliance. And one more thing also is that uh, it slipped out of my mind. Anyway, I will tell you when it comes to my mind once again.
Sudhakar, one more thing comes into the mind. When we say the minutes book is to be consecutively numbered. Now the code of page does not contain any minutes, it's a blank page. Whether in the numbering that should form consecutive numbering or that should be left out without numbering.
It should be numbered, consecutive number. Some people, what they do whenever they are getting it bounded, volume 1, volume 2, volume 3, is to change the page numbers, which is not in compliance with that. That page numbers are to be continuous. And there is no question of any interpretation. Law is very clear. It said consecutively numbered. Consecutive numbering means what?
No. Consecutive number is okay, but only thing is the minutes book when you say, because this page does not contain any minutes, it's a total blank page.
But that is a page.
People,
that is a part of the minutes page, Though it is not recorded, you are scoring it off and then you have to do it.
Okay. Basically, Ashwini, to your question, that why the blank page requires signature, the logic is, minute is continuously written. If anything is left out, that means someone can still write it. And that's why it is required to be scrolled. Okay. Now that scrolling can be done by anything, and it may not be the intention of chairman or board. So when the chairman initial, he knows that this page is scrolled by me only and left like that. And that fact he initial. It's not that scrolling he is initialing. He's initialing and certifying the fact that this minutes is continuous, it's ended, or as per the fact that it ended in previous meeting, and this page is intentionally left, or suppose in between some pages left, this is mistakenly left blank. This fact he is certifying, and that's why that initial is required. So we have to understand it's not scrolling. Why we scroll? The minute should be continuous. Anyone can add, delete, and all that. That should not happen. That's why scrolling. And the chairman is telling, yes, I have permitted this. That's why initial is required.
Yeah, very well explained, Deepti. In fact, Ashwini, that thing, what I have forgotten, now I remembered that. We know that within 30 days, the minutes are to be recorded. Okay. Recording means that you have to also not only finalization of the minutes, you have to engross the minutes on the minute sheets. They may be signed by the chairman after 30 days, I mean, any time before the next meeting or the next meeting itself. Say, for example, you are always having a practice of getting the minutes signed by the chairman at the next meeting. But you have to ensure that minutes are engrossed on the minute sheets within 30 days. Most of the times it happens that people, what they do is the minutes are finalized, they are there in the laptop, they don't engross it on the minute sheets. God forbids if there is an inspection and the ROC, the inspection person asks, where are the minutes of the last meeting? And you say, wait, I will take the printout and I will give it to you. It will be taken as a non-compliance.
Sudhakar,
So,
practically in most companies, the printout is taken only just before the day of the board meeting next time.
yeah,
That is what it is
that is not correct.
normally happening.
That is not correct. Yeah.
Ashwini, we are closer to 1 o'clock. I don't know how many more slides are there because it's already 12:53. Yeah. Yeah, go ahead.
Yeah. So the inspection of minutes. Directors have the right to inspect the minutes of board meetings at the company's registered office or another designated location during business hours. The register may be inspected.
One minute. Sudhakar, whether directors can inspect the minutes of independent directors meeting, which is prepared by independent directors, or note, whatever you say.
No, they cannot.
Yeah.
Because as I told you that they are not minutes under section 118 subsection 10. So technically those minutes are confidential. And if the independent directors don't want that minutes to be circulated, as Vallari has rightly said that they may take a note in the next board meeting whether independent directors meeting have taken place. And maybe the chairman, the lead independent director or the chairman of the independent directors meeting may brief the board if at all he feels like. But technically, you don't need to provide the minutes of the independent directors meeting to the board of directors for inspection. In fact, I have seen one question. That point of time, I said we will discuss it when Ashwini talks about minutes. Whether the recordings of the proceedings of the board meeting are to be given for inspection of any director, or can the director ask for a copy of the recording of the board meeting? The answer is no. You don't need to give copy of the recording to anybody. Similarly, the secretarial auditor has no right to say that I want to view the recording of the meeting. Because board meeting is a very confidential. There are several issues are discussed there. And you're recording the entire proceedings of the board meeting. And except the board of directors, nobody else have the right to have the access of that recording. But even the directors also cannot have copy of the recording. In fact, in one of the JVs, we have this issue which has come up. They say that their auditor wants to view this thing. So we said that yes, we may be able to give. I mean, they may view the proceedings selectively wherever they feel like, but copy of the recording we will not provide. Let me also say one more thing. Another issue has cropped up in one of our JV companies is a director of the JV side wants to do the audio recording of the proceedings of the meeting. Whether he has that right, whether he can insist that he wants to do the audio recording, answer is no. No director has a right to record the minutes of that, to record the proceedings of that meeting, whether it is audio or video. Only thing is, it is the company which is under obligation for having that recording. That recording is also to be maintained up to the next secretarial audit only. After that, it can be destroyed. Yeah. In fact, in one of the companies, the secretarial auditor was insisting that they wants to see all the recordings of the board meeting. I said, no, secretarial auditor has no right to do that. He can
Sir,
see the
even
first,
the
he,
yes.
he can see the beginning, middle, end. That's it.
So validly, he can only see that whether the recordings are available, but he need not get into the recordings. And
Correct.
also the recordings need not be preserved beyond the financial year after which the audit is conducted, right?
Yeah, till
Yeah.
the audit is over, it should be there. Audit is over, then you can decide. That is number one. As Sudhakar puts it many times, people want to have the clarification, etc. But the recording is never passed on to anybody. It is only shown to the concerned director if they want to see it. That's all.
In fact, during the COVID period, one or two company secretaries have called me with a problem because they were holding the meeting for the first time on the video conferencing. They were to record the meeting. In those days, all of the company secretaries were not familiar with this. There's a different Zoom and other platforms. So they thought that meeting is being recorded, but unfortunately, at the end of the meeting, when they saw the meeting was not recorded. So the question was that company secretary got completely baffled that the recording has not taken place. It is a non-compliance. My advice at that point of time was during such a situation we are working, what I gave him the answer is, by God forbids for any of the participants in future, if it takes place also, nothing to worry. You can always tell your board at the next meeting that due to some technical issues, the meeting could not be recorded. And the same may be recorded at the subsequent meeting, and the directors also taken note of that technical issues, that recording has not taken place. However, whatever the minutes are there, the minutes have captured the proceedings properly, and the directors have, giving an information that the VC meeting has taken place, something like that. You do it in the record. Next meeting, have sufficient noting, and secretarial auditor need not qualify the report also. Maybe it is not a non-compliance as such. Sometimes it happens. Issues beyond your control. Okay. And one more thing also in the minutes, please take one thing. Any director is expressing his dissent, chairman has no prerogative to not record the dissent. If any director says verbatim whatever he spoke at the meeting, it is to be recorded in the minutes. It is not correct. It is the chairman's prerogative what to record and what not to record. But any kind of dissent is there. If a director says, I am expressing my dissent, the same may please be recorded. The chairman is duty bound and it is obligatory for him to record that dissent. And I said several times to the independent directors, wherever you are not agreeing, please do express the dissent and get it recorded in the minutes. At the same point of time, sometimes it may so happen, some directors abstain from the meeting, abstain from the voting. Even they may abstain while passing the resolution by circulation also. In such cases, that abstainment is also to be recorded in the minutes. So and so director has voted against. Look, he has expressed his dissent, and so director has abstained from voting at the meeting. That is to be recorded. Because in one of the time, one company secretary called me and he said that they don't want to record the director's name who has abstained. But you have to record that. There is no other option for you. Yeah.
Preservation of minutes. The minutes have to be permanently preserved either in physical or electronic form with a timestamp. If a company has merged or amalgamated, the transferee company has to ensure that it preserves the minutes of the transferor company. All copies of notice, agenda, notes on agendas, and related documents must be preserved for a period of 8 years. Documents from a merged or amalgamated company must also be preserved for a period of 8 financial years. Then minutes have to be kept in the custody of the company secretary, or in the absence of a CS, a director authorized by the board. The report of the board of directors shall include a statement on compliance of applicable secretarial standards in the board's report.
1 minute, Ashwini, 1 minute. See, in the secretarial standards, if you see, it is written that the minutes are to be written, written in clear, concise, and simple language, plain language rather. It is also mentioned that they are to be recorded in third person and in past tense. Somebody asked me this question, of course, long before in one of the forums, that why it is written like this. It should be written in a clear, concise, and plain language. Because number one, minutes, we are not expected to write Shakespearean English. Similarly, minutes are not to be, there should not be a scope for interpretation issues and all those things. Minutes are to be nothing but the proceedings of the meeting, the discussions taken place, deliberations taken place, and the decisions arrived at. And minutes are to be placed in the court of law as an evidence, God forbids, if any issue has taken up. That is the reason why it is mentioned. Now, it is also written that you have to do it in the third person past tense. Obviously, because the proceedings you are recording after the meeting is over, so you have to do it in the past tense only. But the resolution, you have to record it in present tense. Why it is so? Because the resolution, the way it is drafted in the agenda, the board is passing it. That resolution, right from comma, full stop also, you have the way it is presented to the board and passed it, you have to record it in the same way. Even the comma, full stop also, you are not supposed to change technically, because the moment you change a comma in the resolution, the meaning may get also changed sometimes. That's why one has to be very careful about it. And before you go to the case laws, let me also say about the initialing part. There are, sometimes it may so happen, unsigned documents, reports, presentations, several things it so happen, which you are tabling it. They are not circulated. Any item which you are tabling and which is recorded in the minutes, those documents are to be initialed by the company secretary or the chairman for the purpose of identification. Suppose, say, for example, a presentation has been given to the directors. That presentation you are not circulated beforehand, but you have just tabled it and the presentation was made. So that presentation, you have to keep it in the backup papers of the board meeting. That presentation is to be initialed by the company secretary or chairman for the purpose of identification. Any document like that, if you are not circulated, but you are tabling it and you have referred it in the minutes, those are to be initialed. And similarly, once the minutes are drafted, they are not supposed to be modified or altered. If at all any alteration has to take place, it is to be taken up at the next board meeting. And by way of a recording, you can correct it, but not otherwise. The way in the accounting language, what we do is if we pass a wrong entry, we pass a rectification entry. You will not just remove that original entry, what you did. We pass a reverse entry for that. Same is the case here also. Okay. Yeah.
So this case law pertains to providing of the facility of attending board meeting through video conferencing, which Sudhakar sir has explained at the beginning of the webinar, that you have to mandatorily provide the facility to attend the board meeting through video conferencing. And this case reiterates the fact that when other directors had apprehension that they could not provide the facility, NCLT has held that it is mandatory and they have to provide a facility to participate in the board meeting through video conferencing. The second case is the Registrar of Companies has, in case of Madhyam Agrivet Industries Limited, conducted an inquiry and found that the company's minutes book was not numbered, which violates 11810 of the Companies Act. This also we have discussed, and this was considered as a violation. Here we can see the penalty that has been levied by the ROC for the violation of 11810 of Companies Act. On the company, 25,000, on each director, 5,000. So even if the minutes book is not numbered, it is being taken seriously by the regulator and penalties are being levied. In case of Kudos Finance and Investments Private Limited, the Registrar of Companies identified several non-compliances in the minutes book, like the board meeting minutes was not consecutively numbered. Pages of the minutes book were not initialed by the chairperson. Last page of the minute book was not signed by the chairperson. So basically, the compliance with respect to signing was not done at all. The company had not paginated the minutes at all. These violations were again contrary to Section 118 of the Companies Act and Secretarial Standards, which govern the numbering and signing of minutes. Consequently, ROC issued an adjudication notice to give to the company and its directors an opportunity to explain why penalty should not be imposed for these violations. Here also, the penalty levied was 25,000 on the company and 5,000 each on directors, total of 45,000. So with this, I come to an end of my presentation. We can take the questions.
Now we talked about the thing. Can we pass approval of the notice of the AGM and statutory audit appointment resignation through the circular resolution? I think this question we will not take it now because this is going to general meetings. We are talking about the board meeting here. Hypothetically, the director are in flight. This also we discuss, I think. In case of the notice of the board meeting agenda, board meeting, who signs the same? If there is no CS in the company secretary, I think we discussed this. This is authorized director. Can we pass approval of the notice of the same question is repeated? Does chairperson signs or authorized director say, Mr. So-and-so is authorized director or company, she herself delivers her notice to the BM, which is consequently signed by her. Is that correct? The chairperson signed or authorized director say Ms. Kathy is authorized director of company. She herself delivers her notice of BM, which is consequently signed by her. Is this correct? I'm not clear what is this question actually.
See, whatever I understood is that if I am the chairman, I am signing the notice. Okay, whether I have to give a notice to myself, answer is yes. So there should be a proof of dispatch also, and that is to be maintained by the company. So I cannot say I am signing that thing, so I don't need to give a notice to myself. It is required. Suppose my wife is a director. I cannot tell her already tomorrow there is a board meeting, please come over. I have to issue her a notice. So that's how it is.
It can be signed by any director or a person authorized in this regard.
To be authorized by the board. You cannot be, any director cannot sign it.
I am authorized
even the
director.
company secretary, though he is authorized to sign the notice, but the company secretary himself cannot convene a board meeting without the concurrence of the chairman. So he has to seek the permission of the chairman. Then only he can sign the notice.
I am authorized director. The notice board sent to me should be signed by me. This is valid. I think you discussed this. Okay. How do we get the recording file of this very informative meeting? Please advise. What is it? How to get the recording file of this? Okay. This is disseminated in the YouTube. You can get it on the YouTube actually. You can the dissemination take place after the 2-3 days when the meeting gets over. I want to attend the board meeting through the VC. Whom should I inform that I am only the authorized director?
See, when you are signing the notice and you want to attend the meeting through VC, and that meeting is going to take place in a physical mode, so you ask some of your company secretary or any other director to arrange the VC. That's it.
Can a director issue a notice irrespective of there is a company secretary? Can all the director also issue notice and agenda irrespective of the company secretary in the said company?
Valerie, you can also comment whenever you want, please.
Yes, absolutely. I think some of the questions I have answered in the chat also. So this was precisely one of the questions, that whether the person who is authorized and sending the notice, whether the notice has to be sent to the person himself. Yes, it is absolutely correct, sir, also clarified.
Can we pause approval of the notice? Again, the same question is repeated. If the chairman of the MD has included an agenda, if such information could not be obtained, how can the CS complain to them? What is this? If chairman or MD has included an agenda, and if such information could not be obtained, how can the CS complain to them?
Not clear what.
I'm also not very clear what
See,
exactly the question.
what I could get from that question is like this: that chairman and managing director is the same person, and he is not providing the company secretary sufficient information to furnish the agenda. So what he has to do as a company secretary? So if there are independent directors are there, then the company secretary has to tell the MD that the independent directors wants more information. So they have to provide it to him. So these are all practical solutions. We cannot give a answer to that across the board.
Or the requirement of the minimum number of directors and rotation of the directors applicable to a private company, which is a subsidiary or a public company. I don't know what is the rotation of the directors. Where is the question of rotation of the directors? Okay, you are talking about 1/3 retiring by rotation in the AGM. Or the requirement of the minimum number of directors.
Deemed public company, subsidiary of a public company is a deemed public.
Yeah, it is a deemed
public
company.
So it will comply with the provision.
Okay.
But it is not a relevant question.
Can interested person, director participate in the board meeting in a private company?
Yes, I think it was very well clarified. For disclosure has to be given and the person can then participate.
With the permission to host the board meeting through the video conferencing, is the provisional appointment of the alternate director relevant now, since the director can attend meeting online from anywhere in the world?
Actually, we discussed this at the time of alternate director in that also, that yes, it is not relevant. We also discussed. But at present, the provision is there what to do.
Okay. First provision of section 203 says about the chairperson of the company. Somebody has put it. Okay. Is it necessary to the chairperson to summarize all the decision taken if there is a VC in the minutes? Yeah, he has to summarize the
Yes, it is mandatory.
It is mandatory.
It is mandatory.
It is very clearly given.
This cares company secretary very much for drafting minutes. Thanks.
Company chairman joined virtually board meeting late by 10 minutes. At the meantime, board elected another director as the chairman for the board meeting and started the proceeding. After joining the board meeting, company chairman agreed to continue the chair by just elected director. Is it by law who will sign the minutes or previous board meeting or current one?
The elected chairperson.
If director does not respond within 7 days, the circular resolution, what should be understood, whether abstained, rejected, or accepted?
Abstain.
Abstain.
Can video recording be destroyed after audio? I think we discussed this. NFRA is insisting that director should to minutes all their offline private discussions in the management and auditor. Should ID be doing this?
I think this is all up to the directors and the chairman finally to decide what should be recorded in the minutes and not. So I don't think that would be appropriate.
I think Sudhakar has explained very well actually what is the right of the chairman, what to record, except for this dissent. That's what he very well explained actually.
See,
In case,
Bala, this question is NEFRA is insisting that the directors should minute all their offline discussions with the management and auditors should IDs be doing this. See, that recording, what they're talking is not as a part of the board minutes. NEFRA might be asking, that is a different thing altogether. If the directors are having any kind of discussion with the auditors, they may have to be recorded. Recorded does not mean video recorded. That discussions may be recording or something like that as a notes while approving the financials, but not a part of the minutes as such. There's just some kind of an understanding difficulty, I think.
in case of the even voting of the resolution, how the matter is to be considered. In case the director interested is the matter, whether his vote is invalid.
See, Ashwini has mentioned if it is a private company, you have to disclose it and then he can participate in the voting. In other companies, he cannot participate in the voting. If it participates, it is invalid.
Instead of the wet
Interested
signature,
director's vote.
instead of the wet signature, why not the digital signature used in the signing the minutes? That here again, the choice of the company, whether you want to maintain the things in the physical form or in the digital form. That one has to decide actually.
Correct.
Can we maintain the minutes in the electronic? Of course, you can maintain. That is the law permits actually. But only thing is you have to fulfill the requirement with the timestamp, etc. and other thing and all.
Right, not only that, Bala, I say whenever you are maintaining the records in electronic way, it is not like that only minutes I will do it and other statutory records I will maintain in physical mode. It is not so. You have to pass a board resolution also that you are going to maintain all the statutory records in electronic mode. And similarly, whenever you are again changing the modalities, you have to also pass a board resolution. Only when you are maintaining the minutes in electronic mode, then only you can affix the digital signature, otherwise not.
Can we print and maintain the minutes in photostat papers instead of one page blank and putting it declaration that alternate page have left blank intentionally and not counted in consecutive numbering?
Yeah, it can be done like that, but it is to be numbered and it is to be initialed by the chairman also. Instead of scoring off, you are writing it, this page is intentionally left blank. It can be done.
But what he is telling that page is not counted for consecutively number. The question is that left page blank, they are not numbering that blank. That is
They have to number that.
No, it has to be numbered. It is part of the minutes.
It has to be
that is
numbered.
very crucial. That is the proof that it is a continuity of minutes.
In many documents, some pages are intentionally left blank in order to avoid any lapse or fraud. The last page is actually scrolled off at the initial page, the office or testimony of his personal approval. Okay, this is the information. Can the past company secretary inspect the minutes in case the litigation or due regulatory reasons if he has received a show cause notice from the ROC or any other authority?
Yes, see, that company secretary has no right to inspect the minutes, even if there is a litigation also. Because minutes can be inspected only by the directors, board of directors. In case of any director ceased to be a director of the company, then he got a right to inspect the minutes of the meetings during his tenure as a director. This is very clearly given in SS-1. Now, for any reason, if the company secretary got stuck in a litigation, he has no right to inspect the minutes, but he can always request the court to order the company to provide him a copy of the minutes or the extracts of the minutes so that he can defend himself in case of litigation. Even there also, according to me, he cannot ask for the full minutes of the meeting. He can ask for the extracts of the minutes of that part, what he requires to defend himself in the litigation. Then the
Is
court
it,
will order the company to provide him so and so things.
is it necessary that all the agendas should have the proper resolution, or some information agenda can simply give a gist of information?
Yeah, I think gist of
See,
information is also possible because not every matter needs a resolution specifically.
I had a query
wherever
regarding,
in the Companies Act, you have to pass a resolution mandatorily. You have to pass the resolution. Otherwise, minutes can be in narrative form. This is also clarified in the SS itself.
Yes, very well clarified.
I had a query regarding the complaint filed for violation of SS-1 on MCA. How long does it take to get resolved? Because it's been 2 days, but the status of the complaint is still under examination. What is the way forward and how long does the company take to resolve the complaints?
This
I'm-
for
No,
MC
I'm not very clear on this question. I had a query regarding complaint filed for violation of SS-1 on MCA. How long does it take to get resolved? Because it has been 2 days, but the status of the complaint is still under examination. What is the way forward and how long does the company take to resolve the complaint?
Sir, I mean, what I could understand is if a person has complaint against some other company that the other company is in violation of SS-1, 2 days, actually, it's too short period for any resolution because the MCA will need to understand if there is any violation by the other company. And if the company itself has filed any complaint, I mean, that I couldn't understand. What is the way forward? Because if the logical point is only if me as an individual has filed a complaint against another company saying they are in violation, and it could be possible if I'm a director in one of the companies and the company is in violation, and then I'm raising this concern with the MCA. This could be logical. But other than that, I couldn't understand the angle. Sudhakar sir, if you could maybe throw some light.
No, I'm not very clear about the question, Valari. Whatever you say, I may have to go with that only.
No, but one thing is here, what I understand here, if somebody has complained to the MCA generally investigate the complaint first and it takes its time, then it comes back. The 2 days and other thing and all the short period, and there is no question of investigate and all. Finally, a show cause notice is issued. So the complaint will not move forward actually. Whether mentioning the detailed resolution, the board meeting notice is required or mention this, we talked about it. Then like agenda also, you have talked about it myself and all. Why a director cannot get the copy of the video recording of the board meeting when the director is actually responsible for many things under the law. Given SS-1 does not prohibit a director from getting a video recording of the board minutes. Moreover, director is actually responsible for ensuring the confidentiality of all the matters which is considered in nature. Please comment.
See, question is that board meetings, as I have mentioned to you, it is a very confidential, proceedings of that. And when you are parting with the video recording, that where it will go and all, you don't know. Because other directors may object to that. Question is, does he have a legal right to ask for the video recording? Answer is no. If the company wants to provide it, it is they can tell it is their prerogative. If all the directors agree they want to provide a copy of the recording to a director, by all means they can do it. Question is whether the director has a legal right to ask for the video recording. Answer is no.
What is the way
Okay.
forward if a complaint is filed against the company for violation of SS-1? No, it is only an investigation process will take place. That's all. Can a director present in the board meeting abstain from a decision of the particular agenda from, although she is not interested in the agenda? Yes, I think he spoke actually. If you don't agree, you will have to register your decision. In view of the growing economy, we should have more than 4 board meetings. The government should have the amendment at least 6 meetings in a year. No, minimum is the 4 meeting. You can have as much as meeting. Who's actually prohibiting having the board meeting? Why the law should provide 6 or 8? Law says minimum 4. You can have any number of board meetings. Many of the company secretaries are maintaining the statutory register in the Excel sheet and providing the printed copies. As Excel sheet is the audit, whether it is proper compliance. Maintaining the Excel sheet is actually not an electronic form. It is, instead of maintaining it in the physical form, you are maintaining the Excel form. Sudhakar, what is your view?
See, whatever whether it is Excel sheet, because except that your SDD under the insider trading regulations, you don't need to have a software for the maintenance of statutory records. You can maintain an Excel sheet. But the only thing is you have to take the prints from time to time and maintain it. So whenever there is an inspection takes place, you should be, unless until you are maintaining the statutory registers in electronic form. If you are maintaining it in physical form, at any point of time, you have to have the physical statutory records with you.
If a private company does not convene board meeting in accordance with the Companies Act due to dispute between among directors, what will be the liability of the company secretary? What should he do to safeguard himself?
See, only thing is that he can, if there is a dispute among the directors and all, he can put a mail to both the directors. If there are 2, 3, whatever the number of directors are there, put an email to them that as per the law, you have to have this many number of board meetings. It is it's a board meeting is due. If we don't hold the board meeting, it will amount to a non-compliance. Then these are the penal provisions. So send a minute to all the directors concerned, including the chairman of the company, if any. That is the only safeguard what you can have for yourself.
Yeah, that comes
Alari,
to the
anything
end.
else you want to add?
No, absolutely. I was going to suggest the same thing, that have enough evidence and record with you that you have conveyed the statutory provisions and the requirement to hold the board meetings. And then I think that's the best the company secretary can do.
I think that is the end of the question in the chat box. But there is a hand is raised by Anchal Mittal. We can hear.
Yeah.
Yes, Anchal, you can unmute your mic, you can speak.
Yeah, hello.
Yeah.
Yes, sir. So actually, I was just going through a discussion few days back, and someone was like, कि even the, even the VCs, that in the VCs now we cannot have every meeting, every item, like the approval of financials and all. But past going the years, we had been doing so. So had we had been doing the wrong thing, or the person who was discussing with me, that person is wrong in this? Hello?
Your question is that item like approval of accounts
Yes.
well, whether the same can be done through VC board.
Yes.
That is your question, right?
Yes. As far as I understand, every matter can be dealt via VC, as if VC is treated as good as a physical meeting. This is my
Yes, your
understanding.
answer is correct. Yes. I understood the question now. You don't need a physical quorum. Unlike earlier, there was a rule 4 of the board meeting rules wherein you require physical quorum to transact 4 different items, like your board's report, approval of financial statements,
Yeah.
and the prospectus, and one more thing was there. That has
So
been
that was
removed
for
now.
the circular resolution.
No, there are 2 things are there. Circular resolution is separate, and the resolutions which are to pass at the board meeting is separate.
Correct.
Sorry, the requirement of physical quorum is separate.
Correct.
Earlier, there were for 4, 5 items, you were required to have physical quorum. Okay. Though you can pass that resolutions by circulation also, but these resolutions, if we are doing it at the board meeting, you require a physical quorum. That has been removed now. So you don't require a physical quorum for any resolution now. You can pass all the resolutions which are to be passed at the board meeting by VC meeting also. Okay.
Sorry, sir, for asking such foolish question, but can you please share that date, as if that circular or notification, when the same has been notified?
What is that, Rashmi? I couldn't get that. What is that?
Sir, I am asking that you said that now that restriction has been removed. So I'm
Yeah.
just asking that when this restriction has been removed, this has been removed by way of by way of a notification of NCA, na? So
No,
can you
it is
please
an
share that
amendment to the rules.
notification?
It is an amendment to the rule. If I am
Okay,
not
I'll
wrong,
just check
rule
it.
4.
I'll just check it. Thank you so much, sir.
Thank
Yes,
you.
next on
Yeah.
Magesh, you
Yeah.
can speak.
Yeah. Sir, my question is already answered, but I have a counter argument. So, with your permission, I'd like to submit my argument. The question is like in a board meeting as a director, either I can agree to a resolution or I can disagree to a resolution. In addition to that, can I abstain? I don't want to agree or I don't want to have a dissent. So can I say that I am abstaining from the resolution, although I am not an interested director?
You can always do that.
Uh, okay.
That is your right.
You
You can
can
do
do
that.
that, and in the minutes, that is to be recorded clearly that you are abstained from voting.
Okay. So
Whether
abstaining.
in the board meeting or even in case of a circular resolution also.
Okay. But in circular resolution, they give only two options.
Actually, actually they have to give an option for abstainment also, but normally nobody abstains.
Okay.
Yeah. Otherwise, they have
Even
to 3 options.
No, actually, I faced a practical problem in a board meeting when I said that I want to abstain. So the board did not agree. That they said either you can agree or disagree. You can't abstain. So that was the practical problem I faced. And sir, secondly, Sudhakar sir, second issue which you deliberated is regarding sharing the recording of the board minutes. Now, the law does not have any specific provision. It says the board meetings are to be recorded in certain cases and are to be preserved till the conclusion of audit. Now, it does not prohibit any non-sharing with the directors, etc. So, considering that the director holds a position of trust and he has to keep utmost confidentiality, why a director should not get the video recording of the board proceedings? So that was my point of submission.
I will answer your question. If you see in the SS-1, it provides that once the board minutes are signed by the chairman, the certified copies of the signed minutes are to be provided to the directors, unless until they waive it off. Why that provision has been brought in? Originally, it was not there, but subsequently, several representations have been received by the institute saying that the signed copy of the minutes should not be provided because that they may be misused, and there were certain apprehensions were there. Because of that, we said in the revised SS, the directors can waive off their right to receive the signed copy of the minutes. So normally, most of the companies these days, what they are doing is they are obtaining the waiver and they are not circulating the certified copy of the signed minutes. Now the question is recording, video recording. There are two aspects of there. First thing, legally, whether the director got a right to ask for the recording or not. Legally, he has no right to ask for the recording. Legal right is only to inspect the minutes, only to get extracts of the minutes or certified copy of the minutes. Now, it is up to you if you want to share the recording, that is the company's or the chairman's prerogative to do that. Legal right is not there. My advice to any company or company secretary, if anybody asks me, is not to share it, because these days the anything recorded, where it will go to, where we don't know. Once it goes out of your hands, that recording, tomorrow it may be on the social media also. That director may say, look, I have not leaked it. Somebody from the company itself has leaked it. How you will going to resolve that issue? So that is the reason. It is like playing with a fire. Even in fact, when I was working at Reliance, we used to destroy that, or we used to take one person responsible for the recordings of the board meetings. God forbids any leakage takes place anywhere. It is going to be a major issue. How it will be handled, only God knows. So that's why I said that as a precaution and as a legal right is not there. The rest is up to you and your company.
One more hand is risen, but I can't read the name because the instrument name is appearing Samsung. Yeah. Yes, go ahead. Hello.
I think by mistake it is done.
So that's all. We have come to the end of the session. I think
Sorry, I just want to add one point because I was talking and I think in between there was a power outage, so I lost connectivity. The point that was being discussed on if there is dispute between the directors and what the company secretary can do to safeguard. One we suggested was to create enough record to write to the directors, to the chairman that what is the compliance applicable and what are the rules and regulations. Second is also if the secretarial audit is applicable, bring it to the attention of secretarial auditor because any director will be worried about qualifying the audit report. And if not, certainly to the statutory auditors because they also under CARO need to comply and confirm that the company has complied with the provisions of Companies Act. So this will be one way to bring it again back to the directors that this is a mandatory compliance and requirement. That's it.
Last question was there, can we write minute on plain paper? Yeah, any paper is fine. It's not there. I think all questions answered, Mr. Bala?
Yeah, we can close it. All questions are answered. All the hands are risen also answered.
Yeah.
I think Ashwini, great appreciation to you.
There
Because
is
very
one,
nicely you put up everything.
1 minute, Mr. Bala, please
Yeah.
answer this one. Arey, we allowed you to speak, no? We can
Okay.
only send some.
Okay. Go ahead.
You go ahead, no? Samson, yeah, please.
Okay. So my question was already answered, but in continuity to that question, for example, I don't have a CS in my company, all right? Now I am the authorized director of a company. So as per the rules of Companies Act and SS-1, I have to send myself a notice of board meeting, which is subsequently signed by me only. Okay. Now my question is that what we are mentioning in notice of board meeting is that, for example, if any director wants to attend any meeting through VC, through video conferencing, so he has to intimate so and so person within so and so days. So if I am the authorized director, I am sending myself a notice which is signed by me. So whose name I have to mention that? Say for example, I want to attend the meeting through VC. So whom shall I have to inform in that case? I hope the question is clear.
Whoever is the person who has to arrange the VC, if there is a company secretary or any other director or any admin person, give somebody's name, who is the person responsible to organize the VC. That's it.
Yeah, not necessarily your name only. Who is going to coordinate for VC? That person name you have to give.
But for example, if I am only coordinating the VC part, then what would be the answer?
You write your name and your phone number.
And your name only, to organize VC. That's all.
Okay, so that's what I wanted to clarify. I'm sending myself a notice signed by me, and about VC also I have to inform myself only. Correct?
Yeah, that's it. Yeah.
Okay, thank you.
Okay, that brings the end of the question. Dipti, your last word.
Yeah, thanks everyone. Thanks Ashwini for wonderful presentation. Thanks Sudhakar as usual, your sixers and sixers. Thanks Mr. Bala for your expert comment. Thanks Valerie for sharing your experience, your sharing your knowledge and time. Thanks a lot. Thanks everyone for participating.
Dipti, before you conclude, at SSB, we are in the process of revising SS-1 and SS-2 guidance notes. If anyone wants to send any kind of these things, you may please send it to SSB Secretariat because we are going to soon revise the SS-1 and 2 guidance notes. Okay.
Okay.
In fact, some SSB meeting is in progress. I have to attend that now.
Thank you. Thank you.
Valerie, Sudhakar and Dipti, let me tell you one thing very clearly. It's a very, very excellent, elaborative knowledge sharing session. Now it is almost 140. There are still 140 participants are there. It still shows how we are actually disseminating the information, how informative is this, how knowledgeable it is. The credit goes to our expert panelists. Thanks a lot, Valerie Gupta. Thanks, Sudhakar, as usual. Thanks
you.
a lot,
Thank you.
Dipti.
Thank you very much.
Thank you. Thank you, everyone.
Thank you, everyone. Thank you.
Bye-bye.
Thank you. Good weekend.